To everyone's time. It's 1 minute after the hour, so I want to go ahead and get started. My name is Dick Billings, and I'll be the presenter today. But to kick this off, Sonny of the Las Vegas Asian Chamber of Commerce has some comments to make. Go ahead, Sonny.
All right. Well, thank you so much for that. Thank you, everyone, and welcome. Welcome to our webinar for our 401k MEP program. I appreciate all of you logging in and listening in this morning. We're hoping that this will be able to help you out as far as getting some information about your 401k and how it's affected because of the CARES Act. And again, thank you, everybody, all the presenters for doing this. Appreciate it.
Back to me?
Yes.
Okay, great. Thank you, Sonny. And yes, my name again is Dick Billings. As it says on the screen, I am a partner and the director of marketing for Fiduciary Wise, 401k and ERISA 403b plans around the country, and I'll explain a little more of that, all the players here as we go through. But just to give you a little idea of the format, this is going to be, I'll probably talk for 20 or 30 minutes. And then we're going to have times for Q&A. There is a chat feature in the lower right-hand column of if you've expanded your GoToMeeting dialog box. There's a place there that you can send in a question, and that would be true for anyone in case I missed something for some of the other attendees and so forth. We will also be, this is being recorded, so it will be sent out to everyone at the conclusion of today's presentation. And so, as you'll see here, the main heading here. Trevor, we got some feedback. Can we mute everyone? Thank you. Trevor? Ah, got it. Thank you. Thank you. Technology. Okay, so as this screen says, and we're going to talk about, are we going to talk about the CARES Act? The answer is yes. But the COVID-19 issues that are surrounding retirement plan issues are larger than just the CARES Act. And I'll explain that in a moment. Now, this is the typical disclaimer that I give at all my presentations, is that before I was a partner with Fiduciary Wise, I owned my own administrative firm for 401ks and 403bs for 35 years. And as I told my clients, as I told my employees, that documents always control. So while the information I'm giving you today is factual, obviously to the best of my ability, everyone's plan document is potentially different. Everyone's service agreements are potentially different. And so in the retirement plan world, the document always controls. And I'll show you and discuss some disclaimers here, if you will. Somebody will go to the left and some will go to the right in terms of reactions to these, simply based upon how your document is written, as well as obviously what you want to do. But certainly this is not a replacement for individualized tax or legal advice. Certainly at the end, we're going to give you some contact information. So certainly we're more than happy to talk to you about your particular issue, but that's not the intent here, is to replace that advice here. So just to take a step back, the MEP, which is called the Nevada Chambers of Commerce Multiple Employer Plan, was officially started in January of 2020. And of course, we were all gearing up to market that and roll it out. And then all of a sudden, here comes COVID-19. So that's going to be a delay. But as we talked, we thought, certainly we all have retirement plan clients who are asking, in a way, the same questions. What do I do, or must I do to respond to the COVID issue? But I wanted to just take a moment so you can understand who's talking and why we're talking, and our points of view here is the fact that this multiple employer plan is nothing, I mean, it's not magic. It's obviously beneficial to many employers who either have plans or are considering setting up a plan, because in a MEP, and there's different versions of MEP, so I won't get into that today, is that traditionally, if you band together, and this is true of dealing with health insurance, but in the retirement plan world as well, that you get efficiency to cost. So typically, a MEP is less expensive than doing a plan on your own. It's also tends to be more efficient administratively. Most employers I've ever talked to don't wake up every morning and say, golly, I sure would like to learn more about my retirement plans administration. Use of a MEP allows that administration to be more delegated on a wider basis, and those costs spread over a larger number of people. So again, typically the administration is less expensive. And then finally, the oversight of the plan's assets are by experts who voluntarily accept the role of fiduciary. If you set up a plan as an employer, whether you're for-profit or not for-profit, if you're on the board of directors, if you're an officer of the company, you are a fiduciary and subject to the rules under ERISA. And most, again, employers that I know don't want to be, they can't necessarily all get away from being fiduciary, but they want to mitigate their risk as much as possible because, again, that is not typically their area of expertise. And that's, again, the advantage, as I said a moment ago, or up here rather, oversight by fiduciary experts. Now here are the players that are involved in the Chambers of Commerce MEP. Now don't worry about if you don't quite understand all of the terminology that I'm using here, because you'll be explained more of this as time goes on. Primarily by Jenny Kim and Ashley Vingle and so forth, but I just wanted to at least lay out the players. So certainly Sunny, as Executive Director for the Las Vegas Asian Chamber of Commerce, is what's called the lead plan sponsor. And you typically always have a lead plan sponsor in a MEP because of the way the rules are written. Again, my name is Dick Billings. There's actually, I have 4 partners at Fiduciary Wise, but we are the named fiduciary and plan administrator. And I like to explain it as like the CEO. So if you own your own company and you're making your widgets or whatever it is that you do for a business, you love doing that and you are really experienced at doing it. But when you have to oversee the sales department and the HR department and membership or whatever it is that you have to oversee, you'd rather delegate that to someone else. So what would you do? You'd hire a CEO. You're still in charge of the overall organization, but you delegate both legally and practically all of the day-to-day responsibilities to that CEO. So look at us in the MEP setting as basically CEOs of the plan. So we oversee the other vendors and obviously act on behalf of the plan sponsors. So we have AssetMark Investment Services. They are what's called a 338. That's a fiduciary investment manager. So overseeing the assets. Benefit Equity Inc., which Ashley Vingle and Mike Gorlick, and there's just 2, there are a number of employees there, and they are the TPA and the compliance administrator. PCS Retirement is the daily record keeper, and for those of you that are in existing plans and you get online to www.whatever to look at your account, that's a daily record keeper. So they are the firm that keeps track of all the transactions electronically every day within your respective deferral account, your match account, your loan, all that other good stuff. And then finally, Empower Planning, that's Jenny Kim, which we'll be talking more about here at the end. She's physically located there in Las Vegas. She and her team will be running lead in conjunction with Ashley Vingle in terms of explaining how the plan works. So again, I just wanted to take a moment to explain, the various vendors there. So you're an employer. You have a retirement plan, or maybe you're considering one. I realize it's going to be less of an issue if you don't have a plan currently, but let's assume you have a plan and you have employees. Well, as an employer, you either have already faced or you may soon face conditions that will require substantial employee layoffs. Now, my experience with Chambers of Commerce is, well, you get most of your income in the first quarter, so hypothetically, you're not having any. I shouldn't say any, but I mean, you're not having substantial employee layoffs or furloughs at the moment, but you might come a year from today or 7 months, 8 months from today, and so forth. So that point is that that's a predicament you're going to have to deal with, and that will have not only obviously employment effects, but also those of the retirement plan. Secondly, even if you haven't had any employee layoffs, your current and former employees who may still have money in your plan may be faced with financial difficulties that will encourage or force them to look to the retirement plan to satisfy their short-term needs. So let's assume sunny days, you haven't had to lay off any employees, but I can assure you that some of their spouses have either lost their jobs or had some other, in fact, maybe heaven forbid that they've been diagnosed with COVID and so forth, and then they're running into medical bills and so forth. And so these employees are faced with real life financial difficulties, and if they're at their wits end as to where money comes from, and they've got 10 or 50 or $100,000 in their retirement plan account, they may come to you and say, I want to have access to that money. And as we'll talk about in a moment, you may or may not want to accommodate them. And we'll talk more about that in a moment. And then finally, employers are looking for ways, maybe looking for ways to reduce their retirement plan costs. Number one cost typically of any retirement plan is the contribution. And we're going to talk about that here in just the next slide. But basically, what can you do? And that's, again, related to COVID, but not necessarily the CARES Act. What can or should we do to change our contributions, if anything? Finally, most retirement plan costs are borne by the plan, i.e. the participant accounts, but it's not unusual that I would see maybe the TPA fees or other fees paid by the corporation, because there's an additional reason for that we won't get into today. But because of cash flow issues, a company might say, we need to reduce this cost. We don't want to get rid of the plan, but we need to reduce those costs. Those costs, generally speaking, if they're reasonable and normal and ordinary, can be paid by plan assets. That's just an option for you to consider. Let's spend a few moments here talking about the contribution. And again, we've had obviously our current clients come up with this question is, well, are my 2019 employer, again, we're not talking employee deferrals here, we're talking about any employer contribution. That could be a match or a profit sharing type contribution, what's called a non-elective, where you put it in, it goes to everybody. Are the 2019 contributions required? Well, if they've been made physically, then clearly the answer is yes, because that money isn't coming back. But if your contributions are discretionary, and again, that goes back to the issue of what does your plan document say? If they're discretionary and they have not been physically deposited, it is possible that you would not have to make your 2019 contributions. Now, would you have a PR issue if you promised, or at least kind of promised, your 2019 contributions and then you didn't do it? Absolutely. And I'm not suggesting you don't do it. But again, a lot of our clients are looking at ways to cut costs, and while that might be unfortunate, that may be something that you could consider. Well, here we are, May 1st. We're only 4 months into this year of 2020. Are your 2020 employer contributions required? Well, if you've already made them again, if you've already physically deposited them, certainly those are required, because those are not going to come back. Now, I'm going to take an assumption that many of you are on a safe harbor contribution type program, like a basic match, which happens to be dollar for dollar up to 3, 50 cents on the next 2. That's it's called a basic safe harbor match. Is that required for 2020? Well, like everything else in retirement plan world, it depends. When you issued your notice, most plans are on a calendar year, so you gave your employees notice in December of 19 to say, this is what our safe harbor match will be in 2020. Did it have maybe language in it? If it did, then you don't have to make contributions, future contributions for 2020. Or if your plan was not a safe harbor, and again, that's a contribution option within a plan. The plan itself isn't safe harbor, just the contributions are. If you did not elect that, then again, what does your document say? Is it discretionary or required? And it depends. If you haven't deposited in it yet, then you look to the document's language. And if the language says, you don't have to make it, then you don't have to make it. You may still want to, and you may still do that. I'm not certainly suggesting that you want to cut your employees' contributions, but many of us are facing choices that are difficult. And the third option here is the company having substantial financial difficulties. And that's actually, that language has been around for a few years in the safe harbor rules language, that if you're being substantially affected for any reason, not just COVID-19, that gives you some more options in terms of reducing contributions. Now, aside from all this that I've discussed for 2020, assuming for the moment that you cannot get out of the contributions that are accrued or deposited, maybe they're both the same, through today, typically you can get out of your contribution by giving employees a 30-day notice. So if you gave a notice today, then you'd have to make your remaining, let's just say, matching contributions through the end of May, and then you could discontinue it. Now, there'd be consequences if you went from safe harbor contributions to not. Some discrimination testing has to come into play, and many different options. But my point is, depending again on what your company financial situation looks like, you could probably reduce your employer contribution in 2020. How much depends on the plan's language. But I also want to mention this last point of furloughing or laying off employees in 2020. And you may not have done that yet. You may still do so. There's always been a rule that says if you lay off, or if you terminate for any reason, voluntary, involuntary, whatever, more than 20% of your workforce, that's in the plan, of 20% of your workforce, the plan is terminated. And I won't get into all the details of when that physically happens and what physically occurs within the plan document, but clearly if the plan terminates on a given date, the contributions will cease thereafter. If you're furloughing employees, that typically means in the general language that you're just no longer paying them for a set period of time, 30 days, 90 days, whatever. So you're going to furlough 99% of your employees today, but let's say within the next 6 months, they're all back working. Since termination under these rules only happened at the end of the plan year, you're back to normal employee population on 31 December, so that would not be a termination. If they're still under layoff, some are back, it's going to be a facts and circumstances test and you have to look at. But it is just important to understand it, that a lot of employers run through these situations and don't realize their plan's already terminated. They just haven't accepted it or gone through the paperwork to implement the changes that are mandated by ERISA. So now we're going to take the next few slides and talk about CARES Act. If there's one thing you can take away from today's presentation is that all of the CARES Act rules are voluntary, okay? You as an employer have whatever provisions you have in your plan. Excuse me. The fact that the CARES Act came in is fine and dandy, but you do not have to adopt any part of the CARES Act. You can adopt part of the changes of the CARES Act, or you can adopt them all. My point here is just to simply explain the options and maybe give you a few tidbits of advice as to why you wouldn't or would not do some particular changes and so forth. So let me just go through them. This is a misconception, I think, by a lot of employees. The CARES Act says that, let me back up before I do that. Typically, if an employee took a distribution from a plan prior to age 59 and a half, in addition to income tax, assuming their state had income tax, would also pay federal income tax. Well, CARES Act says if it's for reasons of COVID-19 that are mentioned here in these sub-bullets, then it's penalty-free. That 10% penalty goes away, but the income tax is still there. Okay, and I realize Nevada doesn't have an income tax, but they still make tax return plans. I don't think so, but some do, and not salaries. But anyway, the point is the employee does not get out of the income tax. Okay, and as you see that first sub-bullet, how do you qualify? Well, either you yourself are diagnosed with COVID, or a dependent, a lack of child care, or otherwise economically affected. Basically, that's everybody, probably. Not necessarily, but that would include, obviously, a lot of people. Up to $100,000. Typically, there's 20% withholding from these distributions. That's waived. They can roll it into an IRA or back into the plan within 3 years. So that's something that an employer needs to think about. You're going to distribute this money to the employee, whether they're employed or not, because they're still participants in the plan, even if they no longer work for you. Okay? So that money may still come back within 3 years if they choose to do so. And then there's a special income tax proration that's allowed under the law. If you're going to allow these what are called premature distributions before age 59 and a half, you have to amend your plan, which is not difficult, but you have to have the language, because I said earlier, the document always controls, and so you need to make sure that that's done first before you start undertaking any of the CARES Act mobilizations. Loans. So first of all, some of your plans, people here on the line, don't have any loan provisions. Let's just assume that you do for the moment. You have loan provisions in your plan. Well, the current rules in your plan say you can borrow, typically we see, 50% of your account balance up to $50,000. Okay. Well, now they've raised the $50,000 to $100 and the $50 to $100, inclusive of any outstanding loans. So let's say I'm your employee. you're going to raise it to 100,000. I have $40,000 loan already outstanding. I can't take another 100. I'm limited only to another 60. But notice my comment that it may be tweaked, and this kind of goes to my comment a couple of slides ago, is that you might want to liberalize your loan provisions, but you're only going to liberalize the dollar amount, say 50 to 60 or 50 to 80 or 50 to 100, but leave the 50% as it is, or raise it. Either way, there's nothing in the law that says that you simply are taking none of these changes or all of them. They can be tweaked because, again, you have to look at your facts and circumstances, and I'll explain more about that here later on. Also, it's common in the loan world. If you take a loan out, a participant today, they have to start paying it back almost immediately, typically every payroll, but the law says you only have to do it quarterly if you want to. However, there's an abeyance of paybacks until at least January 2021. And then they have to be paid back within the 5-year rule, which of the original loan date. I think it's important as in this third bullet, if you start allowing loans, or you allow loans today, that some of your participants, again, they could be terminated employees, but they're still participants in the plan, no longer employed. And let's assume that's permanent for one particular person. Well, those payments have to be funneled back into the plan. They won't go directly to the plan. They're going to come through your company. So I'm your employee. I'm going to write you a check for $100 or whatever it is every month, send it to you. You're going to drop it in your corporate account, and it's going to be remitted to the 401k with all the other contributions, if there are any, but in the same fashion, electronically uploading and all that stuff. So not that that's a bad thing, but usually, of course, you well know if you have loans that you amortize those through future paychecks. But if they are no longer receiving a paycheck, then it's going to have to come back through as I just described. So this last bullet is if you don't have loans, clearly you have to amend your plan to allow any loans as well as these liberalized rules. Now, if you already have loans, an amendment may be necessary if you want to use the liberalizations. And again, it depends upon whether these numbers that I mentioned earlier are hardwired in your plan or they're referenced to the section of the law that talks about loans. So again, it's just something you have to look into, and it's an individualized situation. Now, if any of you have former employees in your plan now, they're over 70 and a half, then you're already paying them every year their required minimum distribution, or RMD. CARES said nobody has to do an RMD in 2020. Again, voluntary, and I'm going to talk about that here in a second. So this applies to anyone who's turned 70 and a half in 2020 or in some prior year. Also applies to a beneficiary who is receiving a death distribution. The money's still in the plan from your employee who died, and they're receiving money out either over their lifetime or what's called the 5-year rule. And again, if your plan document had that language, some do that they require distribution within the 5 years. Now it'll be extended to 6. If you've already made RMDs physically, and it's less than 60 days since then, the employee could roll it back into the plan or to an IRA for that matter. If it's more than 60 days ago, they're just stuck, okay, with whatever they've been done. Now, obviously, if let's say it's monthly, because some I know plans allow people to take RMDs on a monthly basis, well, then you can cut them off or cease them. But the ones that have already been made more than 60 days back, those can't be undone. Your plan may need to be amended again if you want to waive 2020 RMDs. Most plans that I see are what are called hardwired. In other words, once you're 70 and a half, you have to take the RMD. So in that case, you have to amend the plan to say CARES Act language, blah, 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 to do that. So some plans might not be because, again, they reference the RMD rules, and the rules have already been changed by Congress, so it would do that automatically. But I would make the assumption at this point that you'd have to amend something in your plan. Hardship distributions. Now, again, your plan may have never allowed hardship distributions. And as it says here, the CARES Act made no specific change to hardships. But there was a change a couple of years ago that added a hardship, and I should take a step back. Hardship distributions are for funeral expenses, medical expenses, or to prevent foreclosure on your home, or casualty loss on your home. There's a number. I think there's about 8 different examples. And then a couple of years ago, Congress added if you're in a work in or live in a FEMA declared disaster area, that also was considered an exception eligible under hardship. Well, up until recently, that was tornadoes and hurricanes and floods and such like that. But on March 20th, President Trump declared all U.S. states and territories to be considered FEMA disaster areas. So if you don't have hardships at all, clearly you'd have to amend your plan to allow it. But if your plan did have hardships, it is likely it does not have this declared disaster area as one of the exceptions. So if you wanted, if you wanted to add that as an exception, then it would require a plan amendment. And I should mention, when I mention these amendments, sometimes these amendments aren't required like right away. The law says, oh, you don't have to do it till 2022. My advice is do it now, because you're going to want to go back and make your widgets. And who's going to remember that in 2 years hence you got to amend for something you did in May of 2020? So even though the law allows it, I would not recommend it. So with all these issues, and I sat down and I said, again, these are questions that would apply whether it's the CARE Act or COVID-19 or not, is, when employees come to you, and trust me, I had 20 employees in my company, is, somebody comes up and says, gosh, I wish you'd add provision X, let's just say loans. I'll just put that as an example. I wish you'd add loan provisions to your plan. And you want to take care of your employees. You care about them. They're good people. But amending your retirement plan or even establishing a retirement plan for one person or just two people is generally not a good idea. It's not built that way under the law. So what's the main purpose of a retirement plan? Well, gosh, it's self-evident. It's for retirement. And originally, when retirement plans of the world were all defined benefit plans, that's basically all they were for. Once you turn 60 or 65 or whatever, you got your money. Well, now we have all these exceptions for loans and hardships and in-service distributions and all that. And there's nothing wrong with that. I'm not here to advocate one way or the other. But if your main purpose of a retirement plan is for retirement, then when you're going to make exceptions, it tends to go away from that. And I'll just give you an example, which has nothing to do with COVID, but it had come up a number of times. An employee is coming up through one of my clients and says, I'm going to lose my home unless I get money out of my retirement plan. Okay, that's a problem. Obviously, no one wants to go through bankruptcy or lose their home or whatever. But if you're a good American, you're going to live 20 or 30 years into retirement. And Supreme Court has said that money in a retirement plan is absolutely exempt from creditors. Okay, so yes, I'm an employee. I'm under severe financial distress. But if you have $50,000 or $100,000 in their retirement account, once that comes out, it's no longer protected. And again, that employee is probably going to survive to retirement years, or their spouse or some of their dependents or whatever. It's a hard decision, but it might be better for that employee to file bankruptcy or whatever and to lose those homes, to think of the long term. So again, I understand employees are going to ask, and to tell them no is going to be a difficult position. But again, you have to look at the plan holistically. What's the company's 12-month financial forecast? Right now, your particular firm, you're not laying anybody off, but who knows? These financial changes and distress from COVID-19 are going to be different. And I know in my own particular situation, going back to the 2009 recession, it wasn't until 18 months after it. That's when we saw our income drop, because we had all those employers then terminating their plans. What's the employee's 12-month financial forecast? As I said earlier, maybe those employees you haven't laid anyone off, but their spouse has. So their forecast could very well be different from the company's forecast, but something to take into account. And should we add some but not all of the CARE Act changes? Again, what you have to look at is, who are we doing this for? Why are we doing it? And what's going to be the practical consequence? In general, if you allow loans, hardships, and whatever, and you let one person do it, everybody's going to do it. Now, that's not true. It won't actually happen, but it will be more than one, because they'll just say, hey, if you need money, just go to your old employer and you can get the money out. And is that something that's within your, if you will, philosophy of a retirement plan? Should our company contribution be eliminated or adjusted in some other way? In talking to our clients today, of course, the current situation is my contribution is costing me X. I want it to go to 0. And if they're having financial distress, then that's what they got to do. But let me just give you an example. You're on a basic match, so that's dollar for dollar match up to 3, 50 cents on the next 2, and you say, we cannot afford that. That's costing us between 3 and 4% of payroll. Maybe change the match to 25 cents on the dollar up to 4. So the maximum out-of-pocket cost would be 1%. Again, it's easier for me to say make that interim change or just a partial reduction as opposed to eliminating it. But my point is, it's not an all or nothing option. There are many other options that you can do. So that's really the extent of, oops, I wanted to go over here, and I see I've just lost my screen here, but bear with me a moment here. I'll get right back there. Is the additional contacts that we have here, and I'm going to mention here a little bit, is these are all people that you can contact for various reasons. And again, Jenny is there in Phoenix with her team, and Ashley is in LA, but she certainly has and travels frequently to Las Vegas. That's within her territory. Fiduciary Wise, Tom and I are the main guys that would be doing this. Tom happens to live in Dallas, Texas, and I'm in the beautiful state of South Dakota. So we're certainly available, but obviously we're not just down the street. But the idea here is that what we want to do is simply put out some information, because these are typical questions that come out and for employers, not just because of COVID, because obviously other employees, as I said earlier, maybe have some financial distress due to credit cards or whatever. And so it's important that they, that you have the tools to say, this is the option, and give you something to think about. So Trevor, I don't know if we've received any questions, have we? Are you on mute, Trevor?
So no, I don't see any questions in the chat, and
okay.
I don't have anything here.
Okay. All right. Then I'm going to sign off here. I want to thank everyone for attending, and there will be future webcasts, and we'll be, various topics, probably more about the MEP in particular. And so in the meantime, though, feel free to contact any of us. And we'll be sending this out to everyone who attended, and really want to appreciate your time. So thank you so much. Have a wonderful day.